Thank you very much, Matthew, for that presentation. Beth, for your presentation as well. It's very valuable information. As I move on into my section of the presentation, I just want to start by really thanking NARF, the Native American Rights Fund, for the collaboration and relationship between NARF and NCAI. The ability we have to do things like this webinar, to come together and to really do what we can to help Indian country, to help tribes, and to help Native people in these times that are uncertain. And so I know there's been a lot of information that's been shared already. And so I'm just going to continue on with really a more focus on the underlying federal authority that DHS has, and then how that interfaces with tribal governments. And so to start with, is DHS's obligation to consult with tribes and decisions that they make that impact tribal nations or Native people. Matt was touching on this just at the end of his presentation. He specifically mentioned the policy directive at DHS, as well as the Office of Justice Services responsibility to consult with tribes. And so, as just for your information, at NCAI, what we have been doing is we have been talking with federal decision makers. We are consistently reminding federal decision makers of their duty and obligation to consult with tribes. I specifically want to go over DHS's tribal consultation policy that was adopted in April of 2003 and remains in effect. The policy heavily relies on Executive Order 13175, and that was a tribal consultation policy that was signed by President Bill Clinton in the year 2000. It identifies consultation in four steps, including preparation, notification, input and adjudication, and follow-up and closure. Also importantly, this policy recognizes the distinction between tribal consultation as a form of legal communication and collaboration, as distinct from routine coordination and communication between staff members. And so as NCI, we encourage tribes to reach out to the DHS Office of Tribal Affairs to request consultation if your tribes or community members are experiencing interactions with ICE or the Border Patrol. We can move on to the next slide. And so now I'm going to do a little bit of an overview on the federal authority and the jurisdiction of these federal agencies. And importantly, as a starting point, the federal government does not exercise what's called general police power. Now, police power, when you hear that term, you can automatically think of law enforcement, but police power, general police power, is broader than that. It's the authority to enact laws and regulate behavior and enforce order. The federal government doesn't exercise this broad power. Its power is limited to those authorities that's granted to it in the United States Constitution, primarily in Articles 1 and 2 regarding the legislative and executive authorities of the federal government. And also importantly, when the United States federal government is exercising its constitutional authority, it must abide by the restrictions and limitations that are placed on all governmental actions as outlined in other places in the Constitution. This necessarily includes the Fourth Amendment prohibition on unlawful searches and seizures, which is particularly relevant to our conversation today. Also importantly, under the United States Constitution, that general police power is reserved to states under the 10th Amendment. As I said, in compliance with the Constitution requirements, federal agencies have authority to enforce federal statutory law. These agencies include the Federal Bureau of Investigation and the Drug Enforcement Agency under the Department of Justice, it should say, and then under the Department of Homeland Security, we have the Secret Service, the Customs and Border Patrol, and Immigration and Customs Enforcement. Each of these agencies operate to enforce specific federal statutes, such as federal criminal statutes and federal immigration statutes. And these statutes are distinct from state law or tribal law. And I think that's important to note, that they are. limited to those federal statutory and regulations or federal statutory law and regulations that are promulgated in accordance with those statutes. So we can go to the next slide. Just a quick look at some of these law enforcement agencies and their jurisdictional scope. We have the FBI and the DEA that are within the Department of Justice, and you can see that, as we know, the FBI sort of exercises broad federal criminal enforcement, major crimes, organized crimes, cyber crimes, etc. The Drug Enforcement Agency, of course, has primary jurisdiction on enforcement of drug laws, including the Controlled Substances Act. And importantly, the DEA has both domestic and international enforcement authority. And then we move into these three. One of these three is not like the other, right? We got Secret Service, ICE, and the Border Patrol. All three are under the Department of Homeland Security. For many, many years, the Secret Service was under the Department of Treasury. And we know the Secret Service primarily as the agency that protects the president, but they also have jurisdiction to enforce certain federal financial crimes, for example, the counterfeiting of money. And the Secret Service is by far and away the the oldest federal law enforcement agency. And so it was in the Department of Treasury predating the establishment of several other federal departments. However, in 2002, the Department of Homeland Security was established, and it was established by the Homeland Security Act of 2002. And if we think about what was happening in our country in 2002, like this is in the wake of the after the 9/11 terrorist attacks. And so this is where Congress enacted under the request of President Bush to establish this federal cabinet level agency, Homeland Security. And there were some new components that were put into this agency, but really it took over a lot of long-standing federal components. The Secret Service was one of those that was transferred from the Department of Treasury to the newly established Department of Homeland Security. Importantly, the Authority for Immigration was also put under the Department of Homeland Security. Prior to this, it was primarily within the Department of Justice under an organization called Immigration and Naturalization Services. The Homeland Security Act of 2002 transferred all of those authorities under the Department of Homeland Security, including the Border Patrol, which had been in existence prior to this act. However, it established the Immigration and Customs Enforcement as a federal law enforcement agency aimed at immigration enforcement. Okay, we can go on to the next slide and take a little bit of a deeper dive now into the two primary law enforcement agencies that interface on the immigration space. So ICE again was established by the Homeland Security Act of 2002, and really it was a conglomeration of duties that were found in other areas of immigration law that were put underneath this newly established agency. But primarily, as it relates to what's happening today, ICE's enforcement authority is to identify, detain, and remove individuals, importantly, who are violating immigration laws. So there has to be a reasonable suspicion that there's a violation of an immigration law to trigger ICE's jurisdictional authority. There's no federal statute or regulation that establishes ICE as a general law enforcement agency like there is for the Federal Bureau of Investigation. However, there is a regulation that allows ICE officers to enforce federal law. ICE also does not have authority to arrest U.S. citizens for immigration violations. That authority rests with the FBI or state agencies, and ICE may detain individuals for interfering with its enforcement and removal operations. So really, those are the limitations that ICE has on its authorities. It's not, just a general law enforcement authority. And we can move on to the next slide. And the next slide is about the Customs and Border Patrol Authority. So the Customs and Border Patrol, as I mentioned, have been in existence for longer than ICE, even though they're also under the Department of Homeland Security. And the primary authority for the Border Patrol, of course, is to regulate who enters the United States. And so that is really heightened when you're at international borders and ports of entry into the United States. One of the things that's really important about the Border Patrol Authority is that they have the ability to perform warrantless stops and searches of vehicles within a reasonable distance inside the United States from an international border. The reasonable distance is defined to mean within 100 miles of an international border or point of entry. And so, even though they have this authority, they see the Border Patrol must still have reasonable suspicion to believe that the individual is an alien before conducting such warrantless stop or search. So there still needs to be something, an articulable fact that the Border Patrol can point to before exercising a warrantless stop. And one of the things that I want to mention here is, specifically, I think about those tribes that are located on our borders. I know there's several of them, like the Tono O'odham Nation in Arizona, the Grand Portage Reservation here in Minnesota, St. Regis Mohawk in New York, and there are others. And they have long-standing interactions, of course, with immigration officials because of their geographic location. And that's where you can see something like the Border Patrol Authority is interesting in how they interact with tribes that are close to the border. But for tribal nations and for Native people that are not located near the border, there really isn't a lot of interaction that takes place on a regular basis between those agencies and those communities. We're seeing this unfold now in real time, and that's why it's so important for us as tribal advocates, as staff for tribal nations, and as tribal leaders to understand that duty for consultation that the Department of Homeland Security has toward tribal governments, and to urge DHS to engage in that consultation so that those relationships can be developed. I do want to specifically mention here something that Matt had mentioned and something that has come up a little bit in the comments and that we've seen throughout this webinar. And just to state that as a general principle, and again, this doesn't get into the variance and the nuances of individual treaties and statutes, but as a general principle, ICE and the Border Patrol have authority to enter tribal lands to appropriately enforce federal law. They are not subject to the same limitations as state officials. But this is why consultation and developing ongoing relationships with DHS is critical for tribes. Before I move on to my closing remarks, I do want to mention one other aspect that some tribal leaders may have heard about, and this is Section 287G agreements. Section 287G, it's called that because it was a section that was in a public law that was enacted in 1996. But that section allows the federal immigration authorities to enter into a memorandum of agreements with state and local law enforcement agencies. Importantly, this current administration in the Department of Homeland Security is looking at 25 United States Code Section 2804, subsection E, which allows federal agencies to enter into agreements with tribal law enforcement to carry out laws of the United States. In order to extend these 287G agreements and MOAs to tribal governments. While that's a decision that each individual tribe has to make for themselves, whether that makes sense, it's important to note that these are law enforcement specific agreements between law enforcement agencies for the enforcement of federal law. It does not substitute for the requirement that DHS consult with tribes. Okay, we can move on to the next slide. So we'll move into my closing thoughts before we move into the question and answer portion of the webinar today. There's been a lot of information that's been provided, and we've seen a shifting of long-standing legal positions, roles, and responsibilities unfold before our eyes, both in practices that we are hearing immigration enforcement officers are engaged in, and even statements coming from the United States Supreme Court. I want to mention some of these statements. Last September, we saw Justice Kavanaugh in a concurring opinion in Perdomo versus Nome note that, quote, apparent ethnicity could be a relevant factor in an immigration enforcement officer's development of reasonable suspicion to stop an individual for questioning. This gave rise to implicit racial profiling, and we've seen that play out numerous times in reports that we've heard time and time again. However, in December, Justice Kavanaugh clarified in another concurring opinion in Trump versus Illinois that federal officers, quote, must not make interior immigration stops or arrests based on race or ethnicity. And so in legal terms, this is almost like whiplash, going back and forth between understanding what's the standard, what's not the standard, because we really rely on the courts, and in particular, the Supreme Court, to articulate and interpret what standards law enforcement can utilize. And we're seeing that really shift and go back and forth in a matter of 2 months, for example, in this particular case. And this back and forth in the legal realm creates confusion and fosters a situation where we see inconsistent standards being utilized by law enforcement and decision makers. We really rely on the law to be clear, and the actions we are seeing unfold before us and the decisions being made in all branches of the federal government have created uncertainty. However, despite this uncertainty, it's important for us as Indigenous people to remain vigilant in protecting our communities. We must always stand together in the face of uncertainty as one. This is where it's so important to note that documentation is critical. We must be willing to advocate for our people, to stand our ground, but to not seek that conflict. Finally, I would just want to note that we have covered a lot of information today. I do want to reiterate that the information presented today does not constitute legal advice for any individual circumstance, and we ask each of you to seek out appropriate legal counsel for your unique circumstance that you may be facing. And with that, I think we can move on to the question and answer portion.